Information Risk with David Lotion, powered by Insight Jam.
Hey, it's Doug Atkinson here at Solutions Review, and welcome to another episode of the Information Risk Podcast with David Lotion. He is the principal architect at Knowledge Integrity and one of our Solutions Review experts. David, always a pleasure. Thanks for being with us again.
Thank you. And as you and I were chatting about earlier, I'm very happy to see that our numbers continue to grow. We've got lots more people who are watching and lots more people who I think are interested in information risk. So got a really good story for today.
Well, excellent. This is kind of like this is like the gift that keeps on giving, because there is just so much information risk cases, examples. And what we have for today is called a forfeiture order, effectively from the Federal Communications Commission, which just came out just a couple weeks back around. Well, why don't you get into it? It's around location data.
Yeah, exactly. And I love the way you presented that about the gift that keeps on giving, because it is hard to scratch around looking for some kind of compliance or some kind of non-observance of a law or some kind of enforcement action that isn't related directly to data and information. And the more you poke around, the bigger chunks kind of start falling out. This was a pretty big chunk. And it kind of goes back to a story that happened in 2018, I believe. And if you give me 1 second, I will just check my date. There was an article. It was in May of 2018, and the story ostensibly is about what we could call an industry-wide violation of the Communications Act that resulted in some, huge fines to probably your mobile telephone provider. The major providers were all implicit in this, but the subtext of the story is a little more complicated, and demonstrates both a complex web of data sharing, a revelatory absence of governance, and a sophisticated attempt at definition and classification of mandated policies. So let's roll back to this article. And basically, in the New York Times and in other news articles, but this is a good place to start. It talks about a former sheriff of a county in Missouri, Mississippi County. And it says he used a lesser-known service from a company called Securus to track people's cell phones, including those of other officers, without court orders, according to charges filed against him in state and federal court. And it is a service that can find the whereabouts. I'm reading from this article, and we'll provide a link to the article. The service can find the whereabouts of almost any cell phone in the country within seconds. It does this by going through a system typically used by marketers and other companies to get location data from major cell phone carriers, including AT&T, Sprint, T-Mobile, and Verizon, as documents show. Between 2014 and 2017, the sheriff, his name is Corey Hutchinson, used the service at least 11 times, prosecutors said. His alleged targets included a judge and members of the State Highway Patrol. Mr. Hutchinson, who was dismissed the prior year in 2017, in an unrelated matter, has pleaded not guilty in the surveillance cases. And what I want to point out is later in the article, it talks about Securus, this company. It offers a location finding service as an additional feature for law enforcement and corrections officials as part of an effort to entice customers in a very lucrative but competitive industry, which is essentially finding people. In promotional packages, the company, which is one of the largest prison phone providers in the country, recounts several instances in which the service was used. In one, a woman sentenced to drug rehab left the center but was eventually located by an official using the service. Other examples include an official who found a missing Alzheimer's patient and detectives who used precise location information positioning to get within 42 feet of the suspect's location in a murder case. So basically, without reading the rest of the article, basically we have a story in which an officer kind of goes rogue a little bit because he's got access to this magical service that you can query to find out the precise location of anybody who has a mobile phone. and presumably within 42 feet of that individual's location. That's pretty close, right? 42 feet is basically the distance from one end of my house to the other end of my house. It's and you don't even have to yell to talk to somebody who's that far away.
And this stuff is called, we'll be referring to it, or it may be referred to going forward as CPNI, which is Customer Proprietary Network Information. Basically, if you're carrying around a cell phone, you're carrying around a geo-tracker. And wherever you go with that phone, all that data is being delivered to databases out of cell towers, and in the end, ultimately, all that data is being aggregated and will be sold. Straight up will be sold, unless, well, actually, there are some consent issues here that the FCC very specifically calls out. But I want people to understand it's like amazing what comes from the data, and we'll get into a little of that later as well. But all this data, not just your calls, who you're calling, who called you, who texted you, what websites you accessed on your phone. It's even when you're not doing anything on your phone, your data is flying out of that phone. So everywhere you go.
You're jumping right into it, but I think what we need to do is kind of put a little bit of a context in there, which is that in order to really understand what the issue is here, we have to understand a little bit about the way the mobile phone networks work, and how and individual, when you actually want to make a phone call, how is that connecting? So I'm no expert in this, but I can give you a little bit of that story, which is there are all these, towers, quote unquote, cell phone towers that exist, and you probably see them all the time. If you're in an urban area, they affix them to the side of buildings, or they put them on antennas on top of buildings. If you are in rural areas, they actually will put them in parks on poles. I've seen the weirdest one that I've seen is an extremely fake looking fir tree that is all made out of metal and plastic with cell receivers
I
on top.
I consider it very thoughtful, actually. I've seen them myself, and I'm like, you know what? Good effort.
Yeah.
That tree is ridiculously taller than every other tree, but it does look like a tree.
A little bit. Well, like a Lego tree, you might say. So the thing is that when you're, the whole point about mobile telephony is that you are moving. It's not tied to a line, but actually it's associated with the ability for the phone to essentially register itself with an antenna or one of these towers. And once it's registered there, then it's within the zone of that actual location. But they've got all this other information about, how close you are and where you are and how you're moving within that region. Because once you move out of the zone of one tower to the zone of another tower, it hands off the connection. So if you want to make a telephone call, your phone needs to know which tower it's connected to. And likewise, the tower needs to know which phones are connected to it. And that's the premise that you were just describing, which is that no matter where, I was going to paraphrase that old movie Buckaroo Banzai, where they says, no matter where you go, there you
That's
are.
where you're at.
There you are. So no matter where you go, your mobile.
One of my favorite movies, by the way. I recommend everybody check out Buckaroo Banzai. Early Jeff Goldblum.
Yes. So one of the earlier applications of this, and I'm gonna date myself a little bit, but as one of the interesting applications of this was the cell phone company selling some aspect of mobile data to companies that were monitoring traffic on the highways, because there was, when people are in their cars and they're carrying their mobile telephones, as they drive, they're moving from one zone to another, and the rate at which they're moving is showing what the rate of movement is along these highways. So some of the early companies that were providing traffic data in real time were actually providing data based on the mobile telephone companies providing some aspect of this data to that could then be analyzed and used to calculate the speed at which cars were moving.
Yeah, and in fairness, I mean, this sort of data is incredibly important for law enforcement, and I think it's perhaps no coincidence that that the kind of canary in the coal mine for this particular action was a member of law enforcement, because ultimately law enforcement has access to this data for all the right reasons.
For good reason, and especially the use cases that the company itself gave, those are reasonable use cases. So as somebody with Alzheimer's walks out of their house and nobody knows where they are, and that person doesn't recall who to contact to let them know that they're lost, finding that person is complicated and important, because there's probably other issues that need to be addressed with somebody who is suffering from Alzheimer's. And likewise, if you're looking for a murder suspect, being able to find them based on tracking their phone, that is a reasonable expectation that is often even called out in some of the privacy laws. So an example is in GDPR, the General Data Protection Regulation in the European Union. It explicitly says that the data subject's right to protection of their data is accepted when the data is necessary for law enforcement. Or for preventing danger to another person or to oneself.
But what we had here, just to get back on this particular case, is an example of information compliance risk, because ultimately, and I would say control, what ended up happening, and what often I think ends up happening, is that the data is initially sold from the large carrier, in this case AT&T, they're Verizon. I mean, everybody was kind of implicated in this. And then that goes to an aggregator who then sells it or uses it, but typically sells it again, which then goes down to another data user or potentially a secondary aggregator who then sells it again, and on and on and on. And at some point, AT&T has very little control over what's going on.
So that's the question, which
downstream.
is so not long after that. Again, I'm now reading from an article that was posted on a website, but it's probably in reference to some other article that was published on some news article, that one of the senators from Oregon demanded that the FCC investigate the unauthorized tracking of Americans' locations by this company, Securus Technologies, because the law restricts how and when a wireless carrier can share data and under what circumstances, and you're not allowed to share that data unless you have either the customer's consent or the sharing is required by law. And what that means is that, in those particular cases that the sheriff had done, he certainly didn't have the customer's consent. So he would have had to have some mechanism for demonstrating that it was required by law. And that is, I'm going to read this again. It says, to access this data, correctional officers can enter any U.S. wireless phone number and upload a document purporting to be, quote, an official document giving permission to obtain real-time location data about the wireless customer. And according to the letter, that company, Securus, did not take any steps to verify that the documents actually provide judicial authorization for the real-time location surveillance. So what it's saying is that the rule says if you want to be able to get access to this, you need to show us that you have a genuine legal reason for law enforcement that allows you to see this data. But if all you do is you give us a document that says, I'm giving you permission, we're basically going to take you at your word, which is we're not going to validate that the document that you sent us actually was written by some kind of jurisprudence process and is actually legitimate and is signed by people who have the authority to give you the right to do this. So it's basically the same kind of thing as, just to use an analogy, instead of a search warrant allowing you to a police officer to go into your home, it's like, well, I have this note from my mother that says my dog ate my homework and signed by my mom in a scribbled with a crayon that says, it's okay that I didn't do my homework and therefore I'm allowed to break into your house.
Right. Signed Doug's mom.
Signed Doug's mom, right? Mrs. Doug's mom, right? So the issue here is what you were starting to get at, which is we have a scenario where we have a service or a capability that is exposing information that is it's legitimate under the right circumstances, and people are abusing it because there's the governance process is not overseen by any kind of control mechanism, and that is generally that's bad practice. But when it comes to data, that's a primary example of information risk. This is a vulnerability, which is basically...
Well, and I want to in Section B, factual background of this particular case, I love this. As part of its business, AT&T ran a location-based services program. And AT&T sold access to customers' location information to companies known as location information aggregators, who then resold access to such information to third-party location-based service providers, or in some cases to intermediate companies who then resold access to such information. You've already got, your data enabling 3 value transactions generating revenue down the stream. I mean, there's massive incentive for your data to be replicated and sold, and then resold, and then resold again.
Yeah, and I really want to drill down into that. I have a feeling that we're not going to have sufficient time before our next break to go into the depth that I really want to go about. What you just scratched the surface there. I want to dive right into. I'm going to hold my nose and jump right in. But why don't we take a break first?
Yeah, all right, very good. We'll be right back, where David will then perform the high dive into this quagmire.
Solutions Review is inviting you to join InsightJam.com. What started a few years ago as a social media event to celebrate enterprise technology has now grown into an always-on tech community with live events, discussions, videos, vendor showcases, and industry resources. Our vetted roster of experts, thought leaders, and analysts are sharing tips and tricks daily. So if you're interested in getting involved, join the long list of companies and brands who have already participated by visiting InsightJam.com today. Now back to the show.
All right, David, we're back, and you will now take the leap.
Yes. So I know that these topics are of near and dear to your heart because you have properly anticipated where I want to go with this. But what I want to do first is kind of roll it back and say, okay, why do we even care about this? And the point that we need to make is that there's rules about what you can and cannot do with data. And especially in the telecommunications space, because of the nature of the space, which is it's not only about providing a service of connecting X to Y or making sure that a call from Doug goes to David, because when you make that phone call, on your mobile phone to my mobile phone, there's probably, you think that you're who's your cell provider? I use Verizon. Who's yours? So you would think that Verizon, they would just say, oh, both of you guys are Verizon customers. We're just gonna, pull out, like in the old fashioned when there was a plug board. You call the operator and they pull a wire out and plug it in over there, right? You think, oh, okay, it's one company. There's probably 4 or 5, maybe more companies that are touching this call between the time that you actually press send and the time that my phone starts ringing, because it's got to get, maybe it's completely done within the wireless network. Maybe it's got to take a couple of stops in through the wired network. Maybe not. Maybe there's different companies that have been contracted to handle some parts of those different networks. Maybe some of those companies are actually, each one of them is actually taking a piece of this too. So there's a lot of data and there's rules about who can use that data and for what purpose you can use it. And it really boils down to basically, if you are a telecommunications company, and I'm going to, as I mentioned to you while we were sitting behind in the break, I'm going to go to my favorite cure for insomnia, which is the Code of Federal Law. and I'm going to read from section 47 U.S. Code 220, section 222, privacy of customer information. And then it says right there, it says every telecommunications, I can't even pronounce it, telecommunications carrier has a duty to protect the confidentiality and proprietary information of and relating to other telecommunication carriers, equipment manufacturers, and customers, including telecommunication carriers reselling telecommunication services provided by a telecommunications carrier. And what that really means is that all the secrets about how to connect X to Y or how to connect Doug to David, there's a lot of proprietary information, like what equipment you're using, what equipment, I shouldn't say you're using, what equipment each one of the telecommunication carriers is providing along the way. You know, are they using better services? Because if I am AT&T and I'm routing a call to Verizon and I happen to see that it gets routed through, you know, like Joe's Telecommunications local company, and I look at that and I say, you know what, we can jump right into Joe's neighborhood, build a couple of towers, and we can overtake all of the business that Joe's little company is doing. So because we're AT&T and we can see every piece of this along the way, we can use this to flush out all the small companies. Well, that's not allowed by law, right? I mean, there you're basically using inside information to do non-competitive stuff. So that's what the rule's really supposed to be saying. But while they're in there, they say they haven't mentioned the customers. So they're saying that you also got to protect the customers' data as well. And this is where we see in the forfeiture document, it says carriers are required to protect the confidentiality of certain customer data related to the provision of telecommunications service. And this includes location information, which is customer proprietary network information, or as you properly referred to it earlier, CPNI. And it says that the Federal Communications Commission has advised carriers that this duty requires them to take every reasonable precaution to safeguard their customers' information. And so if we are talking about CPNI, or the proprietary network information that's associated with the carriers, that's because they don't want to allow big companies to drown out little companies. But because it refers back to the customer, it essentially embeds a data privacy regulation or law inside the protection of information to go against or to protect against that non-competitive behavior. So the companies are obliged to ensure that information about location information, which is only one of these data elements, needs to be protected.
Yeah, and there's a lot going on here. So this was a reasonably stiff fine, I would say.
Oh, yeah.
I mean, $200 million aggregated across 4 companies.
Yep.
Something like that.
Yep.
Which, you know, when you go down the litany, and there is a litany of decisions that are made at the FCC, you can go to their website and see all the all the determinations, and it's quite a long list. This one pops right out. 200 million's no joke. But in fairness, it isn't probably anywhere near the amount of money that is being made by the sale of all this data across all the levels at which it's being sold.
Yes, and yes, I think the term pocket change applies here when you look.
That's a big pocket, man.
It's a big pocket, but still, if you're making billions of dollars, then a couple $100 million is, it's not great, but
I appreciate that. But I think I want people to understand that while this thing pops out at you,
it's a big, when you're looking at the other one, this is big and bad, and the badness.
The hell of it is, I can't. I'm struck by, and you started this whole conversation by pointing out how it was unearthed. It was unearthed pre-pandemic.
Yeah.
Back in 2019 or 18.
Yeah, or 2018, yeah.
And it was only unearthed by this kind of, rogue
exactly.
who happened to kind of just stumble upon or what was it? A congressman who happened, or a senator happened to
No,
stumble
I think what happened is the guy got dinged for it, or got arrested for making use of this in the wrong way, or maybe not arrested.
And then the political,
and then it kind of, somebody actually read the article and said, whoa, what? Somebody's actually using.
I'm gonna jump on my bully pulpit, and I'm gonna,
like somebody's
invoke all the powers of the federal government to find out what's going on here.
There's a service where you can find out exactly where anybody is at any time.
But that is such a random way. I mean, this is not how the FCC typically gets involved. It's somebody asks them to get involved. They're not running around sniffing under every cell tower to see if there's any data going out the door.
Yeah,
and this stuff is happening all over the place. But
this is egregious, and you're right. You jump to the to the description of what's actually going on. What's actually going on is a whole network, or a whole hierarchy of data sharing. So just to give a little bit more background, customer location information and the AT&T location-based services business model. I'm reading from the forfeiture document. AT&T provides mobile voice and data services to consumers by enabling consumer mobile phones to make and receive calls or transmit data on their wireless network. As part of its business, AT&T ran a location-based services, or LBS program, until March 2009. Through the LBS program, AT&T sold access to its customers' location information to companies known as location information aggregators, who then resold access to such information to third-party location-based service providers, or in some cases to intermediary companies, who then resold access to such information to location-based service providers. So exactly what you just said. AT&T is taking their location data and they are selling it to aggregators, who will then sell it to other aggregators, who, for all we know, may sell it to even more aggregators, and eventually will sell it to some company that will then provide the kind of service that this Missouri sheriff was exploiting.
By the time it's sold 3x downstream, the provenance of it to you as you're buying it is secondary. It's so obscured. You assume that it came from somebody who's already. Again, I don't want to let anybody off the hook here, but AT&T made the point. It wasn't us. We didn't do this. Their argument is very specifically like we didn't do what ended up happening downstream after it was sold and then resold and then resold.
So they got a couple of different arguments here, right? So one is they claim that the program was governed via contractual provisions that vested AT&T with the oversight authority over the aggregators, and then the aggregators entered into their own contracts with the location-based services providers. So basically, they don't disagree that AT&T was the one that was supposed to have oversight. But they say, well, we wrote a contract that says you have to operate with this data the way that the law says. And then those guys are supposed to then go into their own contracts with the destinations to which they are selling this data that says, okay, well, you need to oblige this. And so, it says the arrangement meant that it was the LBS providers who were obligated to provide notice and obtain consent from consumers, not the aggregators or AT&T. So everybody's pushing this ball around the room. And AT&T asserts that its program, its location-based services program, was subject to a number of safeguards, and that the providers and aggregators had to satisfy requirements which were memorialized in and governed by contract provisions with the aggregators and any parties that AT&T directly sold location information to. So they're saying, okay, well, we wrote it into our contracts, and the contracts obligated the aggregators to monitor the practices of the providers, including by making sure that the location-based services providers notified customers and collected affirmative customer consent for any use of information, which, as we can obviously see, they didn't do at all, right? So what it's basically saying is AT&T, I sold the data to Doug. And I said, Doug, you got to make sure that if anybody's going to use it, that they have customer consent. Doug says, right. And Doug sells it to Ryan and says, Ryan, David said that if you use this data, you got to get customer consent. And he says, yeah, absolutely, whatever. Just give me the data and here's the money. And then Ryan takes it and he gives it to Malia. And they keep pushing it down the road till like, yeah, what am I supposed to do? It's like, a game of here's what you get, and here's what you're supposed to do. And the problem is that AT&T did not verify the customer's consent before providing access to the location information, but it claimed to verify on a daily basis that each request for information was tied to a consent record.
This is where we start to get into what to do. Right.
Yes.
So we have an information risk here. And in fairness, again, if you start to look at the timeline here, this is data from 2009, I believe now, that was originally, the contracts were signed in 2009 or whatever it was. Then by 2018, the violations were understood. It took another, I think it's been 15 years since this all started. And the case has now been settled. Well, and I'm sure the case is not even settled.
Right.
I'm sure there's an appeal, and there's going to be more lawyers involved, and this is going to get strung out.
I mean, what's interesting,
Let's start to get into, where...
Well, let's talk about this from the perspective of information risk, and I'm going to roll back to what we talked about in our first episode, which is what kind of a risk is this? And I would say it's at least two. The first one is the compliance / penalty risk, the penalty for noncompliance. And as you said, as despite my presumption that this is pocket change for companies like Verizon and Sprint and AT&T and T-Mobile, which I think has merged with Sprint, so that they're pretty huge. This is still big money. You don't see fines like this every day. These are pretty big fines. And so, yes, I can call it a monetary risk. I can call it a compliance risk, but that's not really where I think the big hurt is for if you're an AT&T or Verizon. It's the reputation risk, which is basically you are being called on the carpet because you are not only allowing for other people to get access to private data, you're actually exploiting the availability of that data and making money off of it.
Yeah, there's no doubt about it, and AT&T is none too happy about it, nor is Verizon and the others.
Because
Sprint and T-Mobile, because
they think that they're allowed to do this. They think that there's a lot of things at play there. I mean, one is obviously the reputation, which is that we're playing fast and loose with our customers' data, and obviously that is not a public perception that they want promulgated through decisions like this. But secondarily, there are a lot of technical points that they're making, including not the least of which actually is they don't believe this is an FCC. This is the FCC's jurisdiction. I saw in one particular point that they thought it should have been the Federal Trade Commission. that it wasn't even supposed to be the FCC. Right. So they don't want to just kick the carcass around the room. They want to push it into another room altogether. So
well, again, when lawyers get involved, things get nuanced.
well, I mean, there's still some really interesting things here, which is that what's the issue? The issue is governance. And the governance problem here is that when you allow for information to move outside of your administrative domain, then you lose administrative control. And that is something that we've chatted about a little bit before, and something that I focus on when I do. So this past week, I was at a conference. I taught a course on information risk management, and I focus on this, which is that data carries baggage. It's no longer, if I want to share data, that I just have to give you, here's what the data looks like, and here's the number of records I'm handing you. There's obligations associated with that data, and simply put, if a single consumer has said, I don't give you the right to share my information, then when I take that consumer's data and I hand it to Doug, then I got to say, Doug, here's a list of the consumers who have not provided an opt-in for the use of their information, and that you've got to take that and put it in the backpack. And when you sell it to, so you are now the aggregator, you're going to sell it to another aggregator, and you hand it to the aggregator and say, here's the rules for how to use this, for what's allowable on this data that came from the source. And you need to demonstrate to me that you can verify that you are observing those rules. And that's got to get passed around. That becomes a piece of metadata, I'll use that term, that nobody ever thought existed before. We used to think that it was like, okay, well, what's metadata? This is the information data about the data, and like how many columns are there, what are the size of the columns and types, and what are the values that are allowed, and can it be null? Well, that's all structural metadata, but there's all this qualitative metadata or object metadata or fair use metadata that is outside the realm of the technology used for using that data and goes into the requirements for ensuring governance over the proper and appropriate use of that data.
Yeah, see, this is one of my as I think ever since I've been in the technology world, I've always thought that the individual is woefully has had their data woefully undervalued for their own benefit. That the value proposition has always been, well, we'll give you this efficiency online in exchange for your data, and then we're going to take your data and we're going to monetize the hell out of it, but you're not going to see any of it because you got the efficiency of the system and the service and the whatever it is, the lead generation efficiency. And I just feel like that is going to have to change, and it may need some sort of structural governmental edict to change that value equation where because people now represent so much data. They're no longer just, it's not no longer just this point data that they get from providing their contact information in a form. It's now all of this data that you even aren't even aware is part of your data set, if you were, your individual data set. And it just seems to me like, I mean, and when you see that, large company sold it to smaller company, which sold it to smaller company, which sold it to smaller company, and 4 companies have made money off of effectively a piece of your data or your data, it doesn't seem right.
Well,
and that's not where we're going. But this is where I think we need to end up. We
could get on that soapbox, and I'll give credit to, it's kind of funny because like these big technology companies, they make I'm not going to use the word pretense. They make a show of attempting to be protective of your personal information, and the example that I would call to is Apple and the iPhone, and how now every single time you open up an app, it says you need to give permission to use location services, which is exactly this issue that we're talking about with the mobile phones. But really what it's saying is, hey, we not only are we acknowledging that, the mobile phone companies, they're getting your location data, but we're also getting, we're the technology platform. We're also getting your location data. And guess what? We're also allowing developers to build applications that will also keep track of your location data, whether you're running the app or not.
But it's such an extortion play. It's like you either approve whatever it is in our you want to use an iPhone end user licensing agreement, or you don't get access to the app, and right. You don't get the option of saying I'd like it, but I don't want you to be able to resell my data. There's no option like that, right. Which I find, again, is going to have to change. I believe it's going to have to change.
It probably will. I mean, I think that really what we're doing is we're starting to see how the motivation to be protective of personal information is starting to leach into the corporate conscience. And now at least they're acknowledging that they are doing things. Although, again, like in this thing, they're not admitting that they're doing something that is wrong. They actually are trying to argue that what they're doing isn't covered. And maybe after our next break, I'll explain why they say that.
Yeah, no, I will take a break because I could just keep on going on this whole high horse of value and data and control, but maybe I'm just getting ahead of myself. So we'll take a break. We'll come back and we'll wrap it up with, how do you protect yourself from this sort of thing, and what are some of the steps you can take?
And again, remember our objectives are not just to talk about how the consumers are being hurt, but rather how can corporations or organizations, how can they put the right practices in place to ensure that they are not being subject to exposure to reputation risk, penalty risk, those types of compliance risks, those types of things, and that they're doing the right thing that'll make it so that they maintain a level of governance and control.
Want more Insight Jam? Follow us on Instagram for exclusive content like a daily dose of best practices and buying advice from industry experts and leading solution providers. Or subscribe to our YouTube channel for long-form highlights from our expert panel discussions. And if you prefer to listen, please rate and review the Insight Jam podcast on Apple, Spotify, or Google. The Solutions Review team is hard at work collecting the best enterprise technology information from around the globe, so don't miss out. Now, let's get back to the show.
All right, David, we're back. I'm going to walk my way back out of where I just took us, which really is not where we're trying to go at the moment. What we're really trying to do is understand the issues around the information risk for the companies that ultimately receive the penalties here. And I know there's some more information within the judgment order that get into a little bit more about compliance risk and some of the other safeguards that can be taken. Do you want to walk us through some of that?
Yeah, I mean, before we do that, there was just this one interesting component that I think is just worth talking about, which is that one of the I'm trying to track this down. One of the arguments that I think AT&T claimed was that part of their non-responsibility for this was that the law, the communications law, which says, and I'm going back to reading what it says you have to protect the confidentiality of proprietary information of consumers. And I think that the context is when you are providing service to those consumers. And I think they try to make the case that providing service means connecting telephone calls. And in any other use of or any other scenario where data is being collected and it's not for the purposes of connecting telephone calls, that is not it's not covered by this law. And therefore, but yet, as we were talking about earlier, the way that mobile telephones work is each phone registers its location with the cell tower.
This one is a little on the dubious side because I mean, there's a whole bunch of tablet data that connects to these networks as well that they are capturing that they would say is not covered in. It's a little bit of a sticky gray area, but I don't think that's the. I don't think that's where we want to end up.
No, it's not where we want to end up. But I want to make the point that part of this was a sophisticated attempt at definition classification of policy, and this is where we get this challenge in our organizations, which is you've got a team of people who are like the legal and compliance people, and their job is not to manage databases. Their job is to pick apart laws and find where's the fuzzy area where they can kind of allow there to be some behavior that is not against the law. It may not be the appropriate behavior, but it certainly is not illegal. And so we've got the interpreters, and that actually it becomes an information risk. There's a vulnerability there that I started to call out in some of the courses that I teach, which is that misinterpretation of the mandated policy can lead to scenarios where the information management practices are not obliging what needs to be done. And we do get some visibility into this also in the forfeiture document, because we did say that AT&T had the authority to conduct audits. Well, I actually did conduct audits, and I'm looking for where it specifically says what happened. It said that that between 2016 and 2019, AT&T conducted 5 reviews or audits of its disclosure of customer location information to third parties. The company claims that 3 of the 5 analyses are subject to attorney-client privilege. however, and submitted the results only of the 2 reviews that AT&T treated as non-privileged. So that in its own right is a little bit telling, which is that they conducted 5 reviews, and 60% of them they're claiming we can't expose because it has attorney-client privilege, which already makes me, puts my suspicious meter up a little bit. But then I'm going back to reading, the results of those 2 audits identified various issues of concern. One audit, which reviewed the aggregator's compliance with AT&T information security requirements for third-party vendors, identified numerous instances of non-compliance with security requirements by both of the aggregators that were mentioned in the document. The other audit focused on a review of AT&T's controls over certain disclosures of consumer location information for the provision of location-based services, identified issues related to the completeness of subscriber consents and record retention practices regarding subscriber consents. Well, we talked about that stuff already. I mean, again, I'm going to encourage everybody to go back and listen to our first episode, because there we talk exactly about those types of things, which is where are the vulnerabilities and the risks? Things like data completeness, data loss, data availability, record retention, record deletion, those types of things. And AT&T averred that the issues identified in both audits were remediated, and they provided the general topics of the remaining 3 audits, but declined to produce any other information concerning those reviews. And so what we have a situation is what we want to have, which is the information producer, which is the mobile telephony provider or service provider, which in this case is AT&T, has the authority to audit how its location-based services data is being used by the companies, like the aggregators to whom they had provided the data, are doing it, except that 3 out of 5 times they did an audit, they're not telling you what happened. And 2 times that they did it, the other 2 times of the 5, they identified a lot of issues of concern, which they claim to have remediated. However, they obviously didn't remediate it enough, because we still have the availability of this data by rogue queriers to get access to data with only minimally compliant documentation of appropriateness, which is basically their letters that are saying that they have the right to request that data. So we're on the right track here, which is good. If you have this situation, and this will apply to any scenario where you are sharing sensitive information for some purpose with a trading partner, you need to have well-established practices that allow you, as the obligor of some obligations associated with that data, to validate that the target or the acquirer of the shared information is observing what needs to be observed.
My other pet peeve around this is it's all so easy to share. It's just bits and bytes. It's just data, and truth of the matter is it's incredibly easy to share. It's so and it's so valuable now, and it's only getting more valuable. That the financial incentives are so great that you're inevitably going to have difficulty maintaining control over compliance and authorization or whatever, permission.
Yeah, so you have to understand where is the real benefit that organizations are going to get out of sharing this data, and sharing location data can be a really good thing. And an example that I'll give is I had in a course that I was teaching here at University of Maryland, one of my students was working on a project that involved a municipality that wanted to put a circulator bus into practice among the different key points within the municipality: the shopping mall, the supermarket, the parks, the locations of underserved people, so they could get onto a bus and not have to pay a huge amount of money to get to the supermarket, buy groceries, and be able to bring it back home without it being a problem, or being able to get to the mall so they could do, shop for clothing, those types of things. So as a goal at creating a convenience for the citizenry, as well as encouraging increased business by moving people around to where the money gets spent, there's a real reason for doing that. And the student was able to get access to a anonymized location data that it tracked individuals, and the individuals were uniquely identifiable. I'm sorry, I shouldn't say identifiable. They were uniquely tagged with a masked identification. So you could tell that a person walked into this store and then at 12:59 and walked out at 1:22, but you had no idea who that person was. But it was enough information to be able to say, well, now I see that person moved to another location and went to the mall or went to the movie theater or something like that. Being able to understand the movement of people in that scenario was extremely valuable, to be able to build the business case that said, we've got all these people who are not going to places, and we have all these people who when they are on the move, they're going to multiple locations, and they're spending money in multiple locations, and they are going to the different stores that we want to promote in our little village or our little town. So there is value in that. It's when you start going over the line and providing, a service that is used for one set of purposes, but not putting the controls in place to prevent it from being used for other purposes. That's when you're starting to get into trouble. And that's, the same problem that we're talking about here, which is the accessibility to this data by a vetted participant. He's a law officer. He's got the right to use this service. He doesn't have the right to use the data in the context in which he wants it, which is similar to saying, the same thing where you've got a nurse who works at Cedars-Sinai Hospital in Los Angeles, who is allowed to see patient data because she needs to help, I should say, need to help the patients to get better, browsing through the patient list looking for celebrities to see which celebrities are in the hospital for plastic surgery or whatever. So it means that the controls have to have an awareness of the context in which the data is being used. So before we were saying, well, we need governance and we need to have controls that say we need to monitor and ensure that obligations are being met. But it goes deeper than that, because there are some scenarios where the use of the service and the use of the data is mandated to be appropriate, and in other cases, even though the individual has the right to see that data, the scenario or the context in which that individual is looking for that data is not appropriate. Which means that now we're not just talking about, when I talk about my data backpack, we're not just talking about the obligations. We're also talking about all the variables that are relevant in ensuring that those obligations are being met, which include business context, and include location, and include the role that the individual is playing. An individual in an organization may have multiple roles, but it's only in one of those roles that individual has the privilege or the right to access that data for a particular use case.
As I say over and over again, I would argue that data is going to be more and more valuable. There's going to be more and more of it, but we're going to want it to be leveraged, or will be falling behind. I mean, in the end, we want the value of aggregated data so we can understand what works, what doesn't work, it just makes it over time, it creates greater benefits to society to be able to leverage data for, as you mentioned, for societal good, not only for, economic reasons. So this isn't something that is going to stop based upon a $200 million fine. The question is,
what can an organization do?
what does an organization do to prevent itself from becoming a target of an investigation? I mean, how do they create the controls that you're talking about? How do they put in place systems? I mean, what are some of the kind of best practices here for an organization to think about with regard to their control of their data, or the management of permission of their data?
Yeah, so I'm going to go out on a limb and say I don't believe there are best practices, because I don't think most organizations even acknowledge that all this context and associated governance and compliance knowledge needs to be accompanying the data when data is being shared or data is being used. So I will instead say there are good practices, which is we have to understand better how to assert our own internal data policies and how to govern compliance with those policies in a way that allows you to roll up to demonstrate auditable compliance with mandated, externally imposed policies like laws, regulations, standards, those types of things. And this is difficult because it's not a technology problem. It's a process problem. It's a people problem. And it's a mindset problem, which is people don't think about data requiring context. But if we are talking about using data as a resource that is a renewable resource that can be exploited numerous times in numerous ways, we have to make sure that we're doing that in the way that is appropriate for the particular use cases and still remains auditably appropriate, because we're going to start bleeding into unethical use of data and inappropriate use of data. And all this can be managed. This is when I talk about information risk management. This is what I'm talking about. It's being able to govern those policies, to be able to define policies and govern those policies, even if we are exfiltrating data out of our organization and sharing it with others. That we've got. It's not just about can I prevent somebody from accessing data because they don't have the privileges to run a query against that database, because in 5 out of 10 cases that individual is allowed to do it. 5 out of 10 cases that individual is not allowed to do it. And it has nothing to do with the individual or the data. It has to do with what that individual is doing and for what purposes, at what time, in what location.
Yeah, and this is a problem that's only going to get more complex. It's certainly one that we're going to talk more about, and every time we get to go through an example like this, I think we all get a little bit more aware, a little smarter, maybe a little more nuanced around the risks that exist and some of the steps that we can take to just get more responsible and more thoughtful about the management of people's data that large databases are entrusted with, because ultimately, once you've given your data over, you've lost your governance, and you really do hope and trust that who you've given it to will have the best interests of your data in mind. But I'm sure as we go forward, David will find more examples where we'll learn some more interesting things.
There's a never-ending supply of examples. So,
good. So. Well, keep digging through these juicy FCC reports or wherever else you want to find them. But we'll come back in a couple of weeks with another episode of the Information Risk Podcast. If you need any help with any of this stuff, by all means, reach out to David. David is an incredibly smart guy. You can get a hold of him. David, where can folks get a hold of you?
The optimal way is to contact me through LinkedIn. Just do a search on my name. You are hopefully going to find it. Or you can go to the show notes. My contact information is in there as well. Certainly reach out. I'm always happy to talk about these topics. I could talk about them all day long as you have the appetite for it, which Doug, you seem to have a good appetite for it. So
I always find this one of the best hours of the week I spend. So thanks again,
Likewise.
David, for the time and the conversation, and we'll look forward to talking again soon.
Yeah, likewise. Thank you so much.